A lawyer stands up with a polished argument. The brief looks clean. The language sounds confident. Then the judge asks one simple question. Where did this case come from? That is the nightmare hiding inside the latest wave of artificial intelligence in legal work. Not because the draft looks sloppy. The danger is the opposite. It looks finished before it has been earned. According to a March 12, 2026 article from Strategies and Voices, legal leaders are being told to see artificial intelligence as a catalyst. Used carefully, it can sharpen decision-making, improve client engagement, and help train the next generation. But the same article warns that firms still have to protect the human skills that technology cannot replace. For TrialTutor, that is the real lesson. This is not a story about software. It is a story about courtroom credibility. And credibility is built in preparation, then tested under pressure. To be fair, the article is not anti-artificial intelligence. It makes a practical point. These tools can process information at scale. They can spot patterns faster than a tired associate. They can help teams review documents, compare trends, and organize a mountain of material into something usable. The article also says firms do not need perfect grand strategies to start. They can begin with small, contained tasks and build from there. That part matters for trial lawyers too. If a team uses technology to sort exhibits faster, find inconsistencies sooner, or tighten an outline before a hearing, that can create a real advantage. Time matters, clarity matters, speed matters. But none of those things matter if the lawyer using the material cannot defend it live, out loud, in front of a judge. That is where the skill changes. The question is no longer, can the machine draft this? The question is, can counsel stand behind it when the room gets tense? And that is where many lawyers are now getting exposed. In March of 2026, Reuters reported that a federal appeals court fined 2 lawyers after finding more than 24 fake citations and factual misstatements in an appeal. The court said the filings showed the hallmarks of artificial intelligence hallucinations. The judges did not treat this as a tech glitch. They treated it as a credibility failure. Then in April of 2026, Reuters reported that Sullivan and Cromwell apologized to a federal judge after submitting a filing with inaccurate citations and other errors generated by artificial intelligence. The firm said its own policies were not followed, and a secondary review process failed to catch the mistakes. That is the part trial lawyers should not miss. These were not failures of typing, they were failures of verification. Picture the courtroom. Opposing counsel rises. The judge looks down at the brief. A citation does not exist. A quotation is wrong. A proposition is overstated. In that moment, the lawyer is no longer arguing the merits. The lawyer is defending whether the court should trust anything else that follows. That is why this topic belongs on a trial advocacy channel. The teachable skill here is verification under pressure. Not proofreading, not formatting, verification. A trial lawyer has to know which authority actually says what the outline claims it says. A trial lawyer has to know which fact is supported by the record and which sentence only sounds persuasive because it was written smoothly. Artificial intelligence can give a lawyer language. It cannot give ownership. That ownership still comes from disciplined prep. It comes from reading the source. It comes from checking the quotation. It comes from tracing the argument back to the record. It comes from asking the hardest question before the judge asks it first. This is the drill. Take 1 page of argument, then strip away the polish. For every assertion, ask 3 questions. What is the source? What is the exact language? Could this survive a hostile question from the bench? That is not busy work. That is courtroom training. Because when the pressure rises, the advocate who has verified the foundation speaks differently. Shorter, cleaner, calmer. The lawyer is not hoping the sentence is true. The lawyer knows where it came from. The Strategies and Voices article makes another important point. As artificial intelligence takes over tasks once handled by junior lawyers, firms have to rethink training. The article says the profession will need to build higher-order skills earlier, including strategic thinking, asking the right questions, relationship building, and sound judgment. It specifically points to simulations and scenario-based learning as essential. That should sound familiar, because that is exactly what trial training is supposed to do. A young lawyer does not build judgment by copying polished language. A young lawyer builds judgment by making decisions under pressure, then learning which decisions hold up. That is why this moment matters for litigators, law students, and anyone headed toward a courtroom. If technology handles more of the first draft, then human training has to become more deliberate, not less. The profession cannot afford lawyers who sound prepared but have never practiced the stress of defending a position live. And courts are making that crystal clear. Reuters also reported last year that a senior judge in England warned lawyers that using artificial intelligence to cite non-existent cases could lead to contempt findings or even criminal consequences in the most serious situations. That is not a workflow issue. That is a profession issue. So here's the takeaway. Artificial intelligence may help lawyers move faster. Clients also increasingly expect firms to use it in some form, even while firms and clients are still not aligned on exactly how that use should happen. Thomson Reuters says many corporate clients want outside firms using artificial intelligence, but the profession is still struggling to connect operational use with real business impact. That means the edge will not go to the lawyer who uses the most tools. The edge will go to the lawyer who can use modern tools without surrendering judgment. The lawyer who can turn a draft into a tested position. The lawyer who can walk into court and know that every citation, every quotation, and every factual claim has already survived an internal cross-examination. That is the skill to practice next. Before your next hearing, motion, or witness outline, run a verification drill. Pick one argument and force yourself to defend every line back to its source. Practice speaking only from what you have actually confirmed. That is how courtroom confidence is built. Practice that skill with artificial intelligence-powered courtroom drills at TrialTutor.com. Like, subscribe, and share this with a lawyer who wants to be faster without getting sloppy.